So again, I just want to welcome you to our 2021 CEQA update. Thank you for attending. We're broadcasting from Arcata, California, alongside Humboldt Bay, and this is part of our continuing brown bag lunch, which we have every month. As a disclaimer, the views expressed today are not necessarily those of AEP or APA. As another disclaimer, if you think about using this as legal advice, it's kind of laughable, so just don't do that. This presentation is being recorded, and there will be a link sent to you tomorrow. Stay tuned for that. And if you have questions and answers, use the question and answer tab at the bottom of your Zoom windows. Questions will be held until the end of the presentation. But also we may run out of time. And so probably the best, put your questions in there because we have people online that could probably answer them. But best way, if you do have questions, is to feel free to email me and I'll have that information at the end as well. So we already went, yes.
You have an open window that is kind of maybe shading off some of the screen.
Okay.
Do you see that?
I don't.
There it is. It's gone now. Okay.
Oh, good. All right. So just as introduction, I'm usually the host for these monthly brown bag presentations, introducing the speaker, and today I seem to be both. So I mentioned about the questions, but do ask away. And by the way, if you know of any unemployed municipal planners with 3 to 5 years municipal planning or CEQA experience looking to move to rural Arcata, or a senior CEQA planner wanting to move to Reading, SHN has 2 open positions. So I'm not trying to poach anyone from their current positions, but go to our website listed on the slide there if you want more information about the job descriptions. And again, if you request by email, I can send you a PDF of this presentation. So just don't put it in the chat or the questions and answers. So by introduction, my name is Bob Brown. I'm the principal planner at SHN. We have 100 employees consisting of engineers, geologists, planners, biologists, and surveyors in 5 regional offices in Northern California and Southern Oregon. Currently working on on-call planning services to more than 12 municipalities. We do entitlements, CEQA NEPA for private and public developments, and biological and restoration activities. I also teach at Humboldt State University. I've done that for the last 12 years, currently teaching senior engineering students for CEQA and NEPA. Also a North Coast board member of San Francisco chapter of AEP, and I live in Humboldt County. And as you can see, I like outdoor activities. A couple projects in the last few years, we have been or are in the process of helping bring 1,000 or more targeted income housing units online, from Bakersfield farm housing to the City of Eureka homeless veteran housing. In the last few years, we've also helped complete the EIR for the removal of 3 dams on the Klamath River. You may have heard something about that. So here's a brief outline of what we're going to go through, a little bit about AEP and some of the resources that are available. We'll get into the CEQA case law. We'll spend most of our time there and then talk about some of the legislation. And if we have time, go over some of the tools and resources that are available, and ending with waters of the United States versus waters of the state. We'll see. And if you so we may go over the hour. If you decide you can't stay with us, feel free to drop off at the end of the hour or when you need to. So very quickly, just something about the Association of Environmental Professionals. It's $150 membership per year. Currently, there is complimentary student membership, which is typically through 2021. And so I know we have a lot of APM members attending today across the state. Welcome, and it's okay to be in both. But if you ever had a dream about a CEQA project you were working on and maybe woke up in a cold sweat, then you should be considering being a member of AEP. So we have regular CEQA trainings, improving your professional practice. We have case law updates like today, and our legislative committee lobbies to encourage good CEQA legislation and oppose often made bad ideas that the legislatures are considering. And again, if you know of any students that might be interested, membership is currently free. Here's again some of the benefits. And if you attend the state conference and some of the CEQA workshops and things, the discounts are actually more than the membership fee. So consider that today. Again, one of the benefits is getting the 2021 CEQA book. This has the current statutes and guidelines. It has the case law and some of the recent legislation that has passed. It is also available to members as a PDF with a searchable and cut and paste function to it. So just wanted to mention that. Wanted to go to the CEQA portal. So this is the California AEP, so califaep.org, the website here. And if you look, see, I think I have a laser pointer. There's this green tab for the CEQA portal. I just want to very quickly look at this. Remember these good old days where we could meet in person, and this was I think an advanced CEQA seminar or workshop that we put on. So, but if you go to that tab for the CEQA portal, there are two sections. One, there's a list of CEQA topic papers, and then the case law database. If you go to the CEQA papers, here's a list of the papers. Notice a lot of them have been updated in 2020. So you can get some information regarding this. Currently, I think this is open to anyone who goes to the site. It was supposed to be locked down for members only, but it remains open last I checked. And also regarding topic papers, remember OPR has a number of technical advisories regarding CEQA. And then this is the case law database. So if you go there, at the first line here, I just selected alternatives and set, as far as alternatives were an issue, it lists 72 cases, starting with one from 2019 and working backwards. You will notice that if you wanted to get a PDF of the court decision or the summary or actually the actual CEQA document, those are also available. And the current ones are being put up, the CEQA documents, and trying to fill in previous cases. So anyway, another helpful resource to utilize. So some of the topics, I put these in, these were topics that were in the California Land Use Law and Policy workshop that was held a month or so ago. I included this because with attorneys, these are likely to be topics for the next lawsuits that are pursued. So you might take a look at some of these. Note under sea level adaptations, there was two talks. Is managed retreat a taking of private property versus public trust doctrine and the protection of our coastline? So promises to have some friction in those two items. Also, I mentioned there is a case regarding waters of the state that was an appellate court decision in January. So we'll be talking about that next year, but maybe we'll talk a little bit about it today. So again, topics, haven't had one on VMT yet that I'm aware of. This one on wildfire planning. Planning under the US Constitution. I'm not sure what that exactly means, but again, some future topics. An article was written by Arthur Kuhn with Miller, Starr, and Regalia talking about published versus non-published cases of last year. And so published cases are those that can be later cited in future cases. Unpublished means that they can't. And we only discuss the published cases here, but know that there are other unpublished cases that could be useful to practicing CEQA. So out of 36 cases, 17 were published. And the bottom line here is the court seemed to publish those that were the public agency got it wrong instead of getting it right. And maybe it's for us to provide future guidance for us so we don't repeat the same mistakes. Now, these are just some of the topics, some of the summaries we'll go over today. And when I look at these cases, I look at them in a very simple manner, trying to determine how they affect my everyday practice of CEQA. So I'm going to leave out a lot of the details, the legalese and things like that, and get down to what's really important. And some of the other comments. Here are the 19 cases. We will go over the ones in black, the ones in gray we won't. So for instance, the Golden Door Properties deals with greenhouse gas emissions and climate action plans. and would probably take more time than we have today. So I encourage you read them. Go to the AEP CEQA portal if you want more information on them. So, and on some of the other cases, I eliminated some of the more legal points and procedures. So we'll get right into the cases. So Sierra Club versus County of Fresno. This was the Friant Ranch case of a year or two ago. And what we found out was that while they addressed air quality and mitigated air quality, the court said that the EIR was deficient because that did not address what the increase in air qualities would result in for the people living nearby there, and thereby kind of bringing in the requirement for health risk assessments when necessary. So again, this case came back up last year because the county wanted to sever a portion of the EIR, so they only looked at the deficiencies in the EIR. The courts kind of said, no, we're not going to let you do that, even though CEQA section 21-168.9 allows severing. In this case, that was not going to be allowed. They really thought that the lead agency had a responsibility to have a fully compliant EIR certified. However, they did provide some language that the developers or the county would be protected because they would only be re-looking at the EIR sections that issues were unresolved in. So anyway, something that's limited in applicability, but also keep in mind that if you do recirculate an EIR, you are also able to only recirculate those portions that you find may need more attention. Okay, second case. So this was an addition to a 20-year-old legally permitted mini storage. The challenge was filed in February 2017 and construction was completed in October 2017. So not much chance for the project to get held up. Often when a lawsuit is filed, the first thing attempted is to get an injunction so no work can be done on the project. And again, the court would evaluate the rights of the applicant versus the rights of the aggrieved party and whether construction can or can't go. So not a whole lot in here, but I don't know how a judge decides this, but I think it would be good to know what steps you can take to avoid an injunction if you wanted to. So you might ask your city attorney or county counsel for more information on that. But okay, this third case. This was a California Supreme Court case. It was an ordinance that was supposed to be set up a ministerial process. So it addressed ministerial versus discretionary decisions. And as you know, discretionary decisions result in a project as defined by CEQA. So the county ordinance created this ministerial approval process for water well drilling activities. And a lot of the ordinance relied on existing state regulations for where you can safely put in a water well for drinking water and avoid some of the impacts related to hazardous contaminated sites or septic systems, things like that. And the court found that while the ordinance said it was ministerial approval, there was some minor discretion allowed in the approval process, including denial of the permit. So probably the main thing here, some of us are involved in writing ordinances for ministerial approvals, like funded by SB2 and LEAP funding. So we may want to take a closer look at this case on what was considered ministerial and what was considered discretionary. So, and again, a ministerial approval process does not mean it is necessarily statutorily exempt from CEQA. So it may be subject to CEQA. This next case, I don't think, the only reason I included this case is because it reminded me of a Dr. John song. I don't think many of us will have a similar circumstance came up. But basically, two EIRs, months apart from each other, were both approved in 2005. They were both subdivisions of exclusive residential development. The case involved a 2014 partial abandonment of a public road consistent with those EIRs, restricting public vehicle access from project 1 to project number 2. And what the court said was, well, you put the addendum on the wrong EIR. And so the court invalidated the addendum. So the Board of Supervisors was requested by project number 2 to stop public access from project 1, even though that was already prohibited by the EIR for project 1. In fairness to Placer County, do you apply the addendum to the EIR that prohibited the public access in the first place, or the EIR that referenced the first EIR that prohibited the public access? So people were basically ignoring the restrictions or the project description that was approved under the first EIR, which seemed to be more of an enforcement issue. And if already in the EIR, why was an addendum needed? Or in hindsight, they should have added to both just in case. And they actually started to put the addendum on project number 2, which is what the court said they should have, and changed their minds and put it on number 1. So again, redundancy is always good in CEQA. And so just as a good practice tip with categorical exemptions, list as many as apply and be redundant, because if one is successfully challenged, the other may still apply. So this saved Berkeley neighborhoods, again, decided what was a discretionary action. So in 2005, UC Berkeley adopted a master plan and an EIR for increase in student population by 1,650 by 2020. University of California at Berkeley pursued enrollment increasing activities, and by 2017 they had increased population by 8,300 students. No additional CEQA was done. And the court found that enrollment increasing activities, recruiting others from other places, was discretionary activity and a project under CEQA, even if no physical changes to the university had occurred. So UCB made more efficient use of existing buildings and added bedrooms to existing, or beds to existing dorm rooms. And so again, what was the discretionary act that UCB did? They advertised and actively recruited more students, but they did not build any more buildings to accommodate the growth. But incrementally, there were off-site impacts occurring as a result of more students. So this case could have broad implications on what is discretionary act that results in a project defined by CEQA. So for instance, maybe you're in a planning department that just doubled your staff to handle all the cannabis applications that have been submitted. Is that a discretionary act? Is CEQA required to consider it? And then this last bullet point, if there were illegal activities not covered by CEQA that the public were not made aware of, there seems to be no statute of limitations, similar to the 1986 Orange County Fairgrounds case you might recognize. So this challenge occurred, and basically the judge took the challenger's word that they had no access, that actual enrollment had increased to this degree until 2017 when they filed the case. So Willow Glen Trestle Conservancy versus City of San Jose. So we're still talking about discretionary decisions, and therefore is it a project under CEQA? This is kind of a little bit of strange. 1929 wooden trestle. The court previously upheld the city's approval for its demolition, finding that it was not historical. And then after that decision, actually, it was listed under a national or the state listed structures. So, but during the court hearing, the approved lake and stream bed alteration agreement subsequently expired and required a new agreement. Was that a discretionary action? The courts thankfully said no. I mean, every time we'd apply for a permit, would we still have to go through CEQA again? But what the court also validated was that, well, anyway, so it was the applicant that was considered to them to be since they applied for the permit, that they were the ones doing the discretionary act subject to CEQA. And then just as a sideline, the court determined that even if it was CDFW as a lead agency, they couldn't address historic resources because their environmental review was limited to fish and wildlife resources. So if an agency has a narrow environmental review responsibility, they could not extend that authority beyond their boundaries. So for an example, when we worked on the Klamath Dam removal EIR, it was the State Water Board who was the lead agency through the 401 certification process. So for traffic, we analyzed and referenced all the standards we could think of for traffic safety and added that as mitigation, and then said it was outside the authority of the Water Board to require, and found the impact to remain significant and unavoidable. So again, projects on state-owned lands may not be able to mitigate impacts on city streets. CEQA states that lead agencies should be those with the broadest land use authority, but that doesn't always work out that way. So just a very simple case here. Lawsuits filed 1 year after the MND was approved past the statute of limitation, and what the appellants tried to make, that there were mistakes in the MND, and merit should outweigh timeliness. And the court said no, except for in 2 instances. So even though there are flaws in the MND, which would be merit, the timeliness requirements in CEQA outweighed the merit. So here's 2 bullets. So make sure your notice of determination is filed correctly, contains the minimum information required. But here, the second one, the NOD is filed before the decision-making body approves the project. So when does that ever occur? Maybe we have an overzealous staff member that files it. But I was trying to think of a circumstances where this would apply. And NODs are supposed to be filed within 5 days of decision. That's in the guidelines 15075. Along with the CDFW fees, but the appeal deadline for planning action is often 10 days. So if an appeal is denied, then would a second NOD need to be filed if a project is appealed? So something to consider. Again, redundancy, no problem with that in CEQA. So this next case is probably the most important case of the year, especially if you deal with cultural resources and biological resources. This and the Kern County EIR case dealing with oil wells, we'll get to that later, deal heavily with this section 15.126.4. So a lot of detail in this case on how to do 15.126.4 wrong. And I'm guilty of some of those court conclusions. So again, we're glad that this clarification came in a few years ago to CEQA because it allowed us to add specific details to mitigation measures later. But it clearly says that they shall not be deferred until some future time. And then it states further, only when it is impractical or infeasible to include those details during the project's environmental review. So what are the adequate performance standards? A lot of talk about that. So the mitigation measures included in a lot of CEQA documents are typical. Well, the mitigations in these were very typical to what I've seen in a lot of other CEQA documents. And the city used what I would say typical wording for their mitigation measures. But the courts address when is it impractical or infeasible. So waiting a year to do seasonally appropriate rare plant surveys was found not to be impractical or infeasible. And that's usually the classic example. Well, it's August, we just got this application, we're gonna have to send out the CEQA document. And so we're gonna have to act as though maybe the rare plants are on site and here's what we're gonna do because of it and put in some performance standards. So the courts almost seem to take the reverse of this now, is that if your mitigation does not have these required 3 items and clear performance agreement or standards, that may be considered deferred mitigation. Kind of strange, but again, if you're dealing with, the issues here had to do with cultural resources, sensitive plant species, oak trees, and aesthetic impacts. So, and being an MND, mitigated negative declaration, again, we have to deal with the fair argument. So what do you do when a tribe or CDFW requires consultation or additional information because of the concern? You don't want to necessarily ignore their comments. This case was brought by a third party, so they utilized some of the comments that were made by the tribe and CDFW. In regards to oak tree mitigation, the court was provided a lot of information about how oak tree restoration has poor results. And so it suggests that you would need to be on top of the latest research on whether oak tree mitigation is working and how to do it correctly. There was a provision in here for in lieu fee mitigation. And again, a lot of analysis should go up front before you have an in lieu fee program so that you can assure that there are performance standards and that actually somebody paying into as a fee that's actually going to end up with a mitigation that adequately reduces the impacts below significance. So a lot to learn from this case. Again, another one to take a closer look at on how not to do 15.126.4. All right, another case, Cordova Hills. This was a project and an EIR that encompassed a close to 2,700 acre vacant site, currently grazing property. It was a mixed use project, and there was also a future university considered. The end result of development of this project would end up with a population of 25,500 people, including the university. There was a general plan amendment and a 30-year development agreement. And the question that was raised was including, or the comment that was made was including a university lessened the impacts analyzed in the EIR. You're going to have less greenhouse gas emissions, less air quality impacts if a tenth of your property, this was 225 acres set aside for the university, if that was not going to be a university, but may later be developed into more mixed use. So what if the university wasn't built? The county would have other development occur with impacts greater than those analyzed in the EIR. But the court upheld the EIR. CEQA does not require an EIR to discuss future developments which are unspecified or uncertain. Such an analysis would be based on speculation about future environmental impacts. So the argument presented was that the university may never get built. And what actually happened was the university, I think it was the University of Sacramento, College of Sacramento, they were part of the original application, and after the draft EIR was circulated, they dropped out of the picture. And so again, was the EIR, the draft EIR, insufficient? Did the project description change enough that required recirculation? And the court said no to this. So, and apparently the alternative section didn't include an analysis of a project without the university. The court did say that the included mitigation measures were determined to be sufficient. So they did it right. And again, their finding at the very end is the EIR does not have to discuss future developments which are unspecified or uncertain. The development agreement that was included with this had a lot of instruction and mitigation in it. So again, another case to take a closer look at if it applies to you. This is the other County of Kern project regarding 15.126.4. This had to do with drilling of oil gas wells previously allowed by right, when there was this conflict between ag interest and oil and gas interest. So here you are, you're a farmer, and one day you're looking out your window and a drill rig pulls up and starts to drill. And the next thing you know, you have an oil well in the middle of your field. So here the farmers owned the surface rights and the oil industry owned the subsurface mineral rights. So this process is repeated in the county over and over and over again. There are 40,000 wells in Kern County, oil wells, and 900 acres of ag land have been lost as a result of that. So a lot going on here. The county wanted to pass an ordinance for ministerial review that favored the oil and gas industry, and the court set aside the ordinance. And basically, again, they referred to the mitigation being deferred. There was mitigation put in there that probably shouldn't have been. So a lot of the mitigation was fine. It actually reduced the impact. This was mainly hydrology and groundwater supply. They did the studies that they needed to. They added the mitigation measures, and then they came up with a finding that it was still unavoidable, significant and unavoidable, and did a statement of overriding consideration. But there were other mitigation measures that were included in here, such as the 4 largest oil drilling companies should get together and figure out how to have more water go into the groundwater aquifer. or the applicant will need to do a biological report and have to do the recommendations of the environmental report. So things that did not have specific performance standards. So again, I think here the County of Kern put in the mitigation and came up with the finding, but then added these other, I'd call them apple pie type things that were not well thought out. And I would probably suggest that those mitigation measures, it probably would have been better to leave them out because they did not reduce the impact any less. So, and again, this comes to another question about those of us who are working on ordinances for ministerial approvals. So what is deferred mitigation, or what may not be enough performance standards to mitigate? So this also dealt with ag conservation easements. We might be familiar with 3 or 4 different court cases that said if you do an ag conservation easement, it is sufficient. But in this case, because of the timing of the mitigation when it happened. So their mitigation basically occurred 5 years after the oil wells went in. And so that was not sufficient. Mitigation is supposed to begin at or before the impact occurs. So, and then noise, this was kind of interesting. It said, they asked this question for the county to resolve. When is a 20 decibel increase substantial, even if it is less than the county's 65 decibel LDN limit? And when is a 2 decibel increase not substantial, even if it exceeds the county limit? So they did not rely, the court did not want to rely on a county standard, but wanted the individual noise levels to be assessed. And actually the EIR did say that an increase in 5 decibels could be considered significant. So, but then they relied on the county standard. So again, this goes against some of our standard practices and gets the court into the weeds of CEQA analysis. Okay, this is another strange case. The Water District and the Army Corps worked on a project near San Jose. There was a new BART station that was going in there. It was subject to flooding. And when the federal process went through under the Clean Water Act, the Water Board had responded to trying to get the 401 certification approved in order that the project would not lose its federal finding. And as you know, with responsible agencies, which the Water Board is under 15096, a responsible agency has a limited amount of time to act differently than what the EIR that was approved by the Water District. So they're very limited and basically they have to challenge the case or do their own case within a certain amount of time. But what happened was, and I just made these numbers up, is during the EIR process, maybe the project was 60% designed and then the 100% design came out after the federal process was completed. And so what the Water Board did was they rescinded the previous 401 certification and issued a new 401 certification, and that required additional offsite mitigation. And the Water District felt, hey, you guys were a responsible agency. You had your chance to comment. And what the court found was both the Porter Cologne Act and CEQA 21174 allowed the regional board to add these additional requirements. And 21174 says no provision of this division is a limitation or restriction on the power or authority of any public agency in enforcement or administration of any provision of the law which is specifically permitted or required to enforce. So the court also made a statement that they thought it was impossible that a responsible agency would hide in the weeds and then present new mitigation that could have been brought forth in the CEQA process. So I don't think the court considered that sometimes responsible agencies have other priorities or time constraints and they keep them from putting in additional requirements going through the permitting process. But we should not be surprised if we only follow up the legal minimums for project review. But think about additional permitting requirements that might come from the Coastal Commission, from California Department of Fish and Wildlife, the Air Quality District, Regional Water Board, or other state agencies that we send referrals and draft CEQA documents to. I've seen referral forms that basically say, if we do not hear anything from you within 14 days, we will consider that you don't have concerns on this project. So anyway, this case seems to suggest that if they have independent authority, they do not, they can add additional mitigation into their project approvals. Well, that was our CEQA case law. There are 5 cases that are 5 CEQA legislative acts that were passed. Last year, the legislation was pretty much delayed or derailed because of the COVID legislation they had to pass. So a lot of housing projects did not get approved. They just didn't get to the governor's desk in time. These 5 were CEQA projects. Notice the second to last bulleted. There are a couple of other legislation things that passed regarding CEQA and housing and land use. But a lot of this bills failed, not because of merit, but again, because of time restraints. We'll go over these 5. But as we talk about exemptions, I just want to remind you about OPR's technical advisory about CEQA exemptions outside the CEQA statute. So if you just type in OPR technical advisory, you'll get to this section here. So a lot of the recent legislative approved projects, they go and they get placed into other code sections, not CEQA. But at the very end of the legislation, it says, oh, by the way, this is statutorily exempt from CEQA. And so they're put into the health and safety code or some other place. And you will not find them in CEQA. But so this, again, a couple of years old, probably should be updated, but a lot of exemptions outside of CEQA statute should be aware of. So nothing too exciting. This is really just regarding SB 35, which is a ministerial approval, but this requires consultation through California Native American tribes. This next one, and you can see this was a bill added to government code section 65850. So it's not in your CEQA statutes, but establishes a ministerial exemption for emergency standby power generators to serve macro cell tower sites. So you should be aware of that one. Another one is specific to San Diego about the consistency between EISs and EIRs. You might remember a court case a few years ago about alternatives. It was a combined one and it met the requirements for the NEPA, but it did not meet the requirements for the CEQA. And then this last one adds a new statutory exemption for zero emission fueling stations and chargers in urbanized areas, as well as pedestrian and bicycle facilities. So be aware of that. That should be in the new CEQA statute. Now, one more. So this is a ministerial exemption for projects that benefit small community water systems. They make reference to disadvantaged communities as part of that. And that's kind of where I want to go in a few slides from now. But just be aware, this is another section in the statutes. Some 2021 CEQA legislation. These are the new state housing supply legislation. So the deadline for legislation this year was February 19th. These were all put in. These new ones all are redones of the 2020 legislation that did not pass. So again, something very similar to last year being processed through. There was also other legislation focusing on climate adaptation and resiliency legislation. So you can kind of see where the interest of the legislation is. So a number of bills currently going through committees and other places. So keep in mind those. So, and then just a couple of resources. So you should know that all CEQA documents that have to go to OPR or the state clearinghouse require electronic filing. If you haven't gone through that, if you are a consultant and need to file on behalf of a public agency or lead agency, you may need to get permission from them to file it or have them file it. And then site check, I wanted to go over that if you hadn't heard about that, which was primarily for housing exemptions. So again, going to OPR's CEQA.net site, this has current filings with the state clearinghouse, which you can look at. And you can also do under project issue, you can go back and again, pick alternatives and get a number of projects that have, that address that project issue. So keep that in mind as a resource. Opr Site Check. So with a lot of the housing exemptions, you know, you qualify it if you are within these areas here, and you get disqualified using the exemption if there are these environmental constraints. So this is statewide mapping that is available. You can kind of see I checked a whole bunch of boxes and a lot of the areas start to come up. And so again, for housing, it's handy, but also it's a good resource for some of the high elevation type constraints. But you can zoom in anywhere in the state and get parcel specific for some of the constraints there. So again, I question the accuracy, but at least it gives you an idea of some of the mapping that's available. So be sure, I'm sure the utilization of this will expand beyond the housing, but so keep that in mind. And then I mentioned disadvantaged communities. So Department of Water Resources has a mapping. These are income limited disadvantaged communities. But then we also have SB 535 that utilize the same wording of disadvantaged communities. And these are communities that have air quality issues in low density populations that score within the 25% highest scoring census tracts on CalEnviro Screen 3.0. So another use of disadvantaged communities. So if you see a grant application that talks about this is for disadvantaged communities, be sure you know which definition that the grant is looking at. But again, another important and good resource that's being developed. Well, I do have time to go a little bit into waters of the United States versus waters of the state. As you know, it seems like our current administration is reversing some of the things of the prior administration, who reversed some of the things that the prior administration before them did. I don't know how far back it goes, but it's a yo-yo and very difficult for people who prepare documents related to waters of the United States, waters of the state, wetlands, those sorts of things. So in December, end of last year, there was a Superior Court decision that basically said the ability of the State Resources Control Board is limited by the same procedures regulated under the Clean Water Act. And so it seemed like that took away some of the powers of the water of the state. But as I mentioned, in February, so it's not less than a month away, the First Appellate Court in a different court case basically said, again referencing the Porter-Cologne Water Act, that the Water Board does have the right to enforce their waters of the state policies. As I understand, I think the Water Board is currently revising what they have, but this court case helps support that they're doing things right according to the courts. So again, two court cases that have been coming up about this topic. So, but again, we'll talk more about this next year. So I think that is all. Remember, if you have questions, we do have time for some questions. Let me get out of the slideshow and maybe there are some questions to go over. So there was one question about the kern noise. Just a comment, it seems like they had an arrangement similar to the federal process for highway noise analysis. And comment, yes, it is strange. So anyway, now that we're here, are there any other questions or comments that people wanted to add? Well, seeing none, I guess we got 10 more minutes to run out and get some lunch. So anyway, glad you all joined us. Thank you for attending. And again, you will get a link to the recording tomorrow on YouTube for our YouTube site. And if you're interested in a copy of the PDF, then please email me. And maybe we'll see you around next time. Don't forget about the AEP membership.